Hello everybody, I'm attorney Nathan Hauser, and in this video I'm going to discuss denials of workers' compensation claims or denials of workers' compensation benefits. It is my opinion that in the substantial majority of workers' compensation cases, there is always some component of the claim that is being denied. There are some very common reasons why an insurance company will deny a claim, and I'll explain those in just a moment. But what is important is that you have an attorney who is prepared to fight that denial and prove your case in front of a workers' compensation judge. Keep in mind, if you have received a denial of workers' compensation benefits for any of the following reasons, it absolutely does not mean that you lose your case. What it means is that we need to attack the reasons for the denial and take your case to court to prove the insurance company's liability in front of a judge. The most common reasons a workers' compensation claim will be denied by the insurance company are the following. The first, there is no substantial medical or factual evidence to support an industrial injury. This is probably the most common reason why an insurance company will deny a claim. And it's very common that the insurance company will issue this denial even if there is medical evidence and factual evidence of the injury. In my opinion, this is one of the easiest denials to fight and defeat, especially when there's already evidence of the injury. Now, the next common insurance denial will state the claim was made post-termination after the employee received notice of being laid off or being terminated. Now, it is true that the insurance company can deny a case if the injury is filed after somebody has been terminated or laid off. However, what the insurance companies don't tell you in that denial is that there are several exceptions to this rule. And those include if you reported your injury to the employer or supervisor before the notice of termination or layoff, or sometimes even at the same time as being terminated, or the employer knew or should have known about the injury prior to the notice of termination or layoff, or if there is medical evidence existing prior to the notice of termination or layoff. For example, you had gone to your own private doctor for the work-related injury before you were laid off or terminated. And also, if your injury occurred over time or is a cumulative trauma. If your injury occurred over time and you were fired or laid off, there are legal rules that make it very difficult for the insurance company to prevail or win with that denial. So if you worked somewhere for a long time and your injuries occurred over a long period of time, but you were fired or laid off, we can still prove your case and rights to workers' compensation benefits in front of a judge. The next common insurance denial states the claim was not filed within 1 year of the date of injury and therefore it's barred by the statute of limitations. In California workers' compensation, it is very rare that an insurance company will win when they deny a case for the reason that the case was not filed on time or based on a statute of limitations defense. This defense is very difficult to establish because there are many rules that employers and insurance companies do not follow. Even if your injury or injuries occurred up to 5 years ago, depending on the facts, we may still be able to prove your rights to workers' compensation benefits. Some other reasons why insurance companies will deny workers' compensation benefits are that the employee did not report an injury that occurred on the date that is alleged. Sometimes this can be as silly as the date of injury that was sent over to the insurance company by the employer had an erroneous date. Another denial will state that the injury reported was only a minor injury requiring only first aid. This is a common denial that I will see with companies that have on-site nurses that send the injured worker back to work after being seen by the nurse. Some other common insurance denials include there is a dispute about the mechanism of injury, or the employee failed to cooperate with an investigation regarding the injury, or the employee failed to respond to a request for a list of doctors that he or she has seen within the last 10 years. The bottom line with all of these insurance denials of workers' compensation benefits is the following. We will still fight to prove your right to workers' compensation benefits even if the insurance company has denied liability for your claim. If you have received a denial of workers' compensation benefits, it's crucial that you have an attorney fighting for your rights who is willing to take your case to trial and prove the insurance carrier is liable for your injuries. If you have questions about the facts of your workers' compensation case or questions about a denial of workers' compensation benefits that you received from the insurance company, please call or text the number on the screen and we will be happy to give you an evaluation of your case completely free. Once again, I'm attorney Nathan Hauser and I hope to hear from you soon.